Good afternoon, everyone. My name is John Gallo, and I'm the CEO and Executive Director of Legal Aid Chicago. In the midst of the pandemic and threats to civil liberties, our work on behalf of equal access to justice has never been more important. Welcome to our first session of our series on the emerging legal crisis facing Chicago's Black and Brown communities. Today's session will focus on housing evictions. Now, with gratitude to them, it's my distinct pleasure to introduce the hosts for today's sessions, Jamie Jones and Teresa Harmon from Sidley Austin here in Chicago. Jamie and Teresa, take it away.
John, thank you so much. I'm Teresa Harmon. I'm the managing partner of Sidley Austin's Chicago office. Sidley is pleased to partner with Legal Aid Chicago as a sponsor of this webinar series, which focuses on legal issues affecting the most vulnerable in Chicago communities. Sidley has been a proud sponsor of Legal Aid Chicago and a proud partner in its work for over 10 years. On behalf of the 1,300 professionals of Sidley Chicago who provide and support legal services in Chicago and beyond, we thank Legal Aid Chicago for this webinar and for the important work that Legal Aid Chicago does all year long. I'm delighted to introduce my partner, Jamie Jones, who serves on the Legal Aid Chicago board. Jamie.
Thanks, Teresa. We are indeed extremely proud to support Legal Aid Chicago in its mission to provide free civil legal services to people living in poverty in Chicago and throughout Cook County. The 8-part webinar series being launched today will highlight the critical and largely unmet legal needs of the most underprivileged in our community and explore the rising acuity of those legal needs resulting from the COVID-19 pandemic. Today's program begins by examining the legal obstacles to those struggling to achieve and maintain the most basic of human rights, shelter. The Legal Aid Chicago lawyers on the front lines of assisting clients to remain in their homes will help us to understand the challenges their clients are facing and present opportunities to help. Our panelists today are Karen Freeman Wilson, President and CEO of the Chicago Urban League. Joining Karen are Denerica Brooks, Director of Legal Aid Chicago's Housing Practice Group, and Jackie Koryath, Supervising Attorney in the Housing Practice Group. And now I'm pleased to turn it over to Karen Freeman Wilson.
Good afternoon. First, I want to thank John Gallo and the entire Legal Aid Chicago team for the opportunity to join you as you kick off this important series. I'm also appreciative to Sidley and Austin for the sponsorship of this discussion and honored to join the other panelists. What I'd like to do, if it's okay, is to set the table for a conversation that is really much more than just a housing conversation. As we began to shelter in place and prepare for what I don't think any of us understood to be a long-term undertaking, it became very clear to us that COVID-19 was going to have a much greater impact in the Black community, really the Black and Brown community. We understood that the impact of remote education, the impact of having to really either be a frontline or essential worker or being unemployed. The impact of just the incidence of the health care issues that were related to COVID-19 because of some of the underlying issues, the food insecurity, the housing insecurity, all of those issues would have a greater impact in the Black and Brown communities. And that was largely attributable to the structural racism that these communities had suffered over decades, over centuries. And of course, that anticipation became a reality. So as we talk about housing today, just one aspect of that. We thought that it was helpful to at least recommend to you a much larger discussion that we initiated in a paper through the Urban League, and that paper is An Epidemic of Inequities, Structural Racism and COVID-19 in the Black Community. And while we focused on the Black community in Chicago, I think that you will see a number of parallels for the Brown community, for underserved communities, and we certainly recommend that to you. You can find it on our website. If you don't want to read through 66 pages, although we think it's a quick read, there is an executive summary of 7 pages, and you know, we think that you will find both worthwhile. Next slide, please. And so today we are talking about the physical environment, where people live. And if you think about it first globally, we know that there is an issue of hypersegregation in Chicago, in many other communities throughout the country that saw a very large incidence of illness from, and quite frankly, mortality, death from COVID-19, but we're just talking about Chicago today. And so let's look at those environments. We find that in Chicago, both on the south and west side, we see communities where environmental justice is often an issue. What do I mean by that? Where there's a high or higher level of pollution in the communities, where we find housing that might have a higher incidence of mold because of the age of the housing, because of the condition of the housing. All of those factors lead to a higher incidence of underlying diseases, such as asthma, such as other respiratory illnesses. They lead to a higher incidence of COPD. And all of that together makes a person more likely to become ill from and to suffer mortality from COVID-19, because we know from the epidemiology of the disease that if you suffer from underlying diseases, you may likely be more likely to not only contract the disease, but also die from it. And, you know, very closely associated with where you live is what is available to you in your neighborhood. Are you in a food desert? You know, is it easy for you to access fresh food? Very often on the south and west sides, we know the existence of food deserts are extremely likely. And we also know that the unrest that we have seen really over the last 60 to 90 days that were marked through the murder of George Floyd and many other people throughout the country, because of the civil unrest, even the likelihood of having access to food became even a greater concern because of businesses and stores that would close, some of them temporarily, but close just the same. Also, if we think about housing, moving from a global view and going down to a much more micro view of housing, you have to think about, is it possible for me to shelter in place? And that becomes much more challenging for Black and Brown folks, for poor people who may not have the space that others have in their housing. And so if someone is, it tests positive for COVID-19, can you go to the basement? Is there a basement for you to go to? Can you use one bathroom? Is there more than one bathroom in your household? Very often there is not. You don't have that luxury. Another reality is that you don't have the opportunity to stay away from someone who might live in your household who is older. You know, we see more intergenerational households. So if you live with your grandmother, or if you live with an older relative, as an example, for us, we take care of my mom in our home. You don't always have the luxury of staying away from that person, particularly if you are in the position of being a caregiver. This is especially exacerbated in housing where you have frontline workers who may work as CNAs in other places, who may work in grocery stores, who may work as CTA drivers or CTA workers. All of those have an impact on how you shelter, where you shelter. In addition to that, think about group living. Whether it is in a halfway house, whether it's in a group home, whether it is in some type of other group living, not only are you more susceptible to the other people who live in that group setting, whether that setting is the Cook County Jail or some other location where there's group living, but you're also exposed to those individuals who come in to service those in the group home. And so that makes you at a greater, puts you at a greater risk of both exposure to and death from COVID-19. This is also true for nursing homes. We saw just a tremendous outbreak in many of the nursing homes, assisted living settings. And we know that there are people who serve individuals in those nursing homes. They don't live there. They leave the nursing home. They go back to their homes and expose the people, the family members that they live with. All of these things are factors. Now, when you think about the exposure and mortality factors that impact housing, you then move on to the concept of being at a greater risk because of all of the other factors, the loss of jobs, the layoffs from jobs, the reduction in income. It then makes you at a more susceptible to two of the factors that most likely impact your housing. One, eviction. If you are living in apartments or if you're rental housing. And two, foreclosure. Now, we've seen temporary measures that have been enacted both at the local, state, and federal level to impact evictions, to impact foreclosures, but we know that those are stopgap measures and that they will not exist forever. And so that's not my discussion to have today, but we are very fortunate to have someone who lives and breathes that work every day, even though we do have a very active housing program here at the Urban League that focuses on evictions and foreclosures and really preventing people from being evicted or foreclosed upon. But today we're very fortunate to have Denerica Brooks, who is the director of the housing department at Legal Aid Chicago, and she's going to talk to you today about the legal aspect of this very real problem.
Thank you, Ms. Freeman-Wilson, for that introduction. My name is Denerica Brooks, and I'm the Director of Housing here at Legal Aid Chicago. One of the things that I want you to do is to just sit with something for a minute. 40 million people could face eviction by the end of the year. That's according to global advisory firm Stout that has been tracking eviction numbers using US Census Pulse data. That's 40 million people over the next 4 months. Now, eviction has been directly tied to health disparities and adverse health consequences in individuals and their families who have been evicted. So think about that, 40 million people. 40 million people with an increased risk of homelessness. 40 million people with diminished mental and physical health. 40 million people with an increased risk of depression, anxiety, and suicide. 40 million. 40 million people that may be trapped in a cycle of poverty, not just for themselves, but for the next generation of their families as well. Now, as Ms. Freeman-Wilson noted, there have been several temporary measures that have been implemented in order to try to encourage people to shelter in place, but also to stave off this wave of evictions. We have the CARES Act from March 27, 2020 that was implemented. We have federal, state, and local interventions that have served as a lifeline for many renters. After the CARES Act, our governor entered an executive order in April that actually prohibited the filing of evictions. So between March 27th, when the CARES Act was implemented, and April 23rd, if you go back and look, dozens of evictions were still being filed every day until filing was prohibited. So one of the many misconceptions is that the CARES Act was broad and that it protected most tenants. The CARES Act, for those that don't know, applied only to federally assisted housing and those properties with federally backed mortgages. That only accounts for about 30% of residential tenant properties across the nation, 30%. So statewide, our moratorium was issued on April 23rd, and again, dozens of filings were still filed every day, eviction cases that are pending. And so our courts actually stepped in, and due to the moratorium, all of the court cases have been continued until after the statewide moratorium expires. That is currently set for August 22nd because of a couple of extensions of the eviction moratorium in Illinois. On the local level, in the city of Chicago, there's a COVID-19 Eviction Protection Act, and the focus of the new ordinance is to prevent evictions and encourage landlords and tenants to enter into agreements where the issue is non-payment of rent due to COVID. Under the ordinance, the landlords must give a tenant a second notice in addition to their non-payment of rent notice. The second notice notifies tenants of their rights under the COVID-19 Eviction Protection Act. Specifically, the notice must alert tenants that they can request in writing an attempt to negotiate a settlement if their loss of income or non-payment of rent was due to COVID-19. And the ordinance also requires that the landlord make reasonable attempts to reach a settlement over the past due rent. Now, there are certain things that I think it's important to know that the ordinance does not do. While the ordinance does not allow the landlord to ask about personal assets or personal property and the tenant's ability to pay, the ordinance requires that the landlord not reject an agreement solely because the tenant has rental assistance from a third party like a charity or the city of Chicago. And the landlord may not charge unreasonable interest or late fees. Nonetheless, the new ordinance does not prevent evictions for lease violation reasons other than non-payment of rent. So it's very important to note that the new city ordinance only applies to non-payment of rent cases. The ordinance also does not mean that tenants do not need to pay rent. The whole point of the ordinance is for the tenants to work out some kind of an agreement with the landlord and try to work out a repayment agreement. And if that repayment agreement cannot be reached, the ordinance does not prohibit a landlord from filing an eviction if an agreement cannot be reached. So with these temporary measures and these temporary solutions, why should we worry? A lot of people seem to think that tenants have nothing to worry about, that they've had it easy during this whole crisis. So with all of these interventions, why be concerned? Well, we should be concerned because of the short and long-term devastation of evictions. In Illinois alone, according to the Stout Eviction Estimator at the end of July, at least 500,000 Illinoisans could face eviction over the next 4 months. Can you imagine the stress that that will place on already struggling social supports and systems? Systems that now have capacity limits for those that come into offices where people have to maintain social distance of 6 feet, and also organization and social supports that have moved to remote access and remote work. That then leads us to a digital divide. The reality is, and in our nation, do not have adequate access to technology. They don't have Wi-Fi. Some people don't have smartphones or Zoom. And therefore, accessing services and even a court in this new digital age is going to be extremely difficult for some of the poorest and the most vulnerable people in our society. I am deeply concerned about the day that I have to watch a tenant go to trial and present evidence in eviction court over the telephone. And that's what this digital divide looks like. And for those residents that cannot access technology, cannot access Zoom or Wi-Fi or a telephone, the most vulnerable, we're asking that they go appear in person for services, that they appear in person for court. And those that will have to appear will be some of the most historically minority families and historically those already hardest hit by COVID. Avoiding eviction is also critical when it comes time and time again, is that the filing of an eviction alone serves as a stigma and a barrier to an access of housing. Whether a tenant works out an agreement after the eviction is filed, whether a tenant wins their case at trial, just having that eviction on a public record serves as a barrier to access housing. Landlords will look at that and they will think that the tenant did something wrong or was otherwise not a good tenant. And then tenants are stuck in this cycle of renting housing that either is subpar or with landlords that don't do credit dictated by an eviction that is on the record. Matthew Desmond once said that eviction is to women what incarceration is to men. Of those to face eviction than white men. And when evictions are held in person or when they were held in person, you can see this. Because if you just go to the Daily Center in one of the eviction courtrooms or any of the suburban courtrooms, and you look around the gallery and you look at the benches, those are the people that you see sitting there, primarily Black women. Those are the named defendants, and those are the women that are going to have credit issues and evictions on their record that will, again, limit their housing. Will be disproportionately affected by eviction. This isn't a myth, this isn't a guess, it isn't a hypothesis, it is known. This has historically been the case. And we know this because even pre-COVID-19, 80% of evictions were filed against Black and Latinx residents. Here in Chicago, we know that the South and West Side have the highest concentrations of evictions filed. We know that South Shore is the eviction capital of Chicago. According to a US Census Pulse survey, even now after COVID-19, 50% of Black and Latinx families have indicated that they cannot pay their rent compared to only 20% of white families. And it's only going to get worse as new data and research shows that job loss after COVID-19 has disproportionately affected Black and Latinx families, families that don't have the luxury of working remotely or whose businesses have been shut down or shuttered. The other reason that we are concerned is that despite these protections, despite the things that have been implemented to protect tenants during COVID-19 as they shelter in place and even after as the economy slowly opens, is that despite these things, it's just not safe for residents as landlords get desperate and as the moratoriums extend. What we are seeing is the reality that landlords are still issuing eviction notices to tenants. That occurred all through the CARES Act, that occurred through federally backed properties with federally backed mortgages. Landlords were still issuing eviction notices to tenants. To avoid the CARES Act requirements on non-payment of rent cases, we've seen landlords getting creative and giving termination notices that allege cause. And when you ask what kind of cause we're seeing things like a tenant having guests that wasn't wearing a mask in the hallway, or a tenant having a guest who went outside to smoke and was not wearing a mask because they were smoking. We've seen an increase in termination notices over noise complaints and also housekeeping. Other things that we've seen are judges entering eviction orders because they say that the moratorium really applies to the sheriff. So judges are entering eviction orders and staying execution until the expiration of the moratorium. What that means is that the judges are entering eviction orders and saying that the sheriff can then go out and evict people after the moratorium is lifted. And we're also seeing landlords engaging in and threatening illegal lockouts. And one of the things that we've seen most recently is a violation of the Illinois Immigrant Tenant Protection Act, where landlords lock out tenants, and when tenants try to regain entry or contact legal aid, landlords are making veiled threats about knowing about their status or knowing that they or someone in their household are undocumented. We actually had one case where we were able to get a tenant back into his unit to gather his belongings, but he no longer felt safe going back to his apartment, which he was rightfully entitled to, because he was afraid that at any night his landlord would call ICE and have him removed or deported. The other things that we are seeing are an increase in domestic violence. As increased stressors are present with lack of job security, lack of finances, and being home, increased stressors have increased domestic violence. Calls to the Illinois Domestic Hotline have been up 15% according to the network, and texts to the Illinois Domestic Violence Hotline are up 2,000%. And I just want to remind you of that 40 million people again, because as domestic violence increases, prior to COVID-19 in 2019, there were 14 days where there were no shelter beds available in Chicago and 19 days with only one bed available. So as these numbers increase of housing stability and survivors trying to find shelter, there was already a problem with not enough. So as those numbers increase, our social services are going to be even more stressed than they already are, and more people are going to be vulnerable and at risk. Now, my colleague, Jacqueline Correa, is going to speak to you more about domestic violence and the Fair Housing Act.
So as Danica said, I'm Jackie Correa. I'm a supervisory attorney in the Housing Practice Group. So I just want to let you know that some of the matters I'm going to discuss today may be triggering to someone who has experienced domestic violence or sexual assault. A large focus of my work is assisting survivors of domestic violence and sexual assault, and I'm going to be speaking about how those issues intersect with the COVID-19 crisis. During the COVID-19 crisis, we've noticed an increase of calls related to gender-based violence and housing discrimination. As Danica mentioned, the majority of our clients are women of color who are disproportionately affected by domestic and sexual violence and sexual discrimination. After experiencing domestic violence, women encounter additional barriers to finding or maintaining housing due to the acts of their abusers. Similarly, women of color disproportionately experience sex discrimination through racialized sexual harassment in housing. Sexual harassment in housing is underreported because women experiencing it fear retaliation, economic concerns, embarrassment, or have concerns about their physical safety. These concerns are elevated for the low-income clients we work for because they lack the resources to relocate, or if they receive housing assistance like a housing subsidy, they face barriers to moving with that subsidy. So on your screen right now is a word cloud, and it's words focused around the phrase gender-based violence. So gender-based violence is commonly defined as acts perpetrated against a person based on gender norms and unequal power relationships. Of course, people can be subjected to gender-based violence irrespective of their gender and sexual orientation. When I speak about these issues as it intersects with my work, I frequently use a word cloud to capture words that people associate with gender-based violence. I like word clouds because gender-based violence is a big issue, and through this tool, people can submit words that they associate with gender-based violence, and then what the cloud does is it illustrates which words appear more often. So looking at the most recent time I did that, which is what's on your screen, you'll see that certain words were more powerful to people when they were thinking about what gender-based violence really is. And so the words that stand out most to me and that are the largest on the screen are control, manipulation, isolation, power. So thinking about these words that are most predominant, it's important to consider how these issues are impacted by the isolation that is the COVID-19 crisis. It's also important to understand how these definitions evolve over time or are different based on different populations. So Danica spoke about the various stay-at-home protections issued in Illinois. The purpose of a stay-at-home order is to keep people safe. However, stay-at-home requirements have given power to abusers by giving them opportunities to isolate survivors, eliminate support networks, and perpetrate abuse at any time of day. Danica also highlighted data regarding the increase in domestic violence. What this data shows us is that survivors are struggling to get help while isolated at home with their abusers. Additionally, increased need for help depletes resources for shelter or services that are already limited. The combination of all of these factors leaves survivors of violence very vulnerable during this time. So looking at the consequences of this, landlords have focused on CARES restrictions or non-payment moratoria, like Danica discussed, and what we've seen is that landlords are issuing eviction notices to survivors based on incidents of violence by their abusers. We have also seen landlords pressuring tenants to exchange sexual conduct for rent. So I'm going to dive into those issues coming up next. So how does Legal Aid Chicago help? So what you have on your screen is a list of laws and ordinances and protections, and we use all of these all of the time because it's essentially a toolkit that we use to help survivors of domestic violence and sexual assault. Today, I'm going to be focusing on the Fair Housing Act because it's a powerful protection for survivors of gender-based violence and sexual harassment. So getting to the Fair Housing Act. So who does the Fair Housing Act protect? So the Fair Housing Act protects people in protected categories. So as you'll see, it's race, color, national origin, sex, familial status, and disability. It also applies to most housing, including subsidized and unsubsidized housing, with pretty limited exceptions. When does it apply? So the Fair Housing Act also applies to all stages of housing, the application, kind of eligibility stage, when the person's actually occupying the unit, or in eviction proceedings. So how do we use it at Legal Aid Chicago to prove discrimination? There's two main theories that we use to prove discrimination under the Fair Housing Act. The first is direct evidence of discrimination. In the context that I'm talking about, sex discrimination, especially as applied to survivors of domestic violence, a good example is a landlord saying that he doesn't want to rent to women with a history of domestic violence because he doesn't like drama. We also are able to disparate impact theory. So disparate impact means that a landlord may have a facially neutral policy. So if you look at it, it looks okay. But the way that the policy plays out is that it has a discriminatory impact on a protected class. So once again, focusing on the population we're talking about today, women, we're looking at one-strike policies or screening policies or nuisance laws. So I'm going to go into sexual discrimination and sexual harassment in more detail now. So starting with discrimination based on sex. So survivors of violence frequently experience discrimination based on the acts of their abusers or based on their history connected to domestic violence. So for example, repeated calls to the police or zero tolerance policies or criminal activity by their abuser. So this type of discrimination punishes survivors for the abuse inflicted upon them. So we know that women are overwhelmingly the victims of domestic violence and sexual assault. This means that discrimination against survivors of domestic violence or sexual assault is almost always discrimination against women. Again, going back to the theories that we use in these situations, direct evidence of discrimination or unequal treatment. So direct evidence means that there's direct evidence, maybe even the landlord's own words, or a policy that looks discriminatory when you look at it. So a very recent example of this that I've had is when a housing provider wrote a tenant a letter saying that it would not rent her because she was experiencing domestic violence. I mean, obviously on its face, that's discriminatory, and it's direct evidence of discrimination. Looking at unequal treatment. What that means is that a housing provider is treating victims of domestic violence differently than victims of other crimes. For example, a landlord that has a policy that it will not repair damage caused by abuse because it's a domestic issue. That's something that we see a lot, and you can see that through that treatment, it's treating survivors of domestic violence different than other crime victims. Finally, going to disparate impact. So again, disparate impact is a neutral policy that disproportionately affects victims of domestic violence. So a good example of this is zero tolerance policies, because for a zero tolerance policy, a landlord will evict an entire household based on the criminal activity of one person. Even if the landlord applied this consistently to everyone, it will disproportionately affect survivors of domestic violence who are often evicted as a result of their abuser's conduct. So moving on to what sex discrimination looks like. So for the purposes of this presentation and in light of the current COVID-19 crisis, what we've done is we've highlighted a couple cases that have recently come in where we've been able to intervene and help the tenant. So the first tenant was living in a project-based Section 8 apartment. So project-based Section 8 is a subsidy where the subsidy stays with the unit. And what happens is that HUD has a contract with a private owner and subsidizes that unit. So what that means for the context of this example is that the tenant can't just leave the unit, otherwise they leave the subsidy. So for this client, who I'm gonna call MP, her abuser came to her unit with a weapon and injured one of their minor children when he was coming to attack her. There had been a history of domestic violence, and she was trying to stay safe from him, but he still found her. So the case came into us because the property manager issued an eviction notice based on MP's abuser's conduct. Of course, we intervened and contacted the property manager and explained that they couldn't evict her for abuser's conduct. And as a result of our intervention, I'm happy to share that MP and her minor children are safely housed. Moving back to just the second example is CH. So CH was in the Housing Choice Voucher Program. So the Housing Choice Voucher Program is a little bit different than the Project-Based Section 8 program, because with a voucher, the person can move with the subsidy. And that's important because you'll see how we were able to remedy this situation. So CH was living in her unit, and her abuser engaged in a long pattern of abuse, but one piece of that abuse was that he would try to get her evicted so that she would become homeless and therefore rely on him. So he came to her unit, caused property damage, and said that I want you to lose your subsidy and I want you to be out on the streets. So as a result of his conduct, rather than holding him responsible, CH's landlord attempted to evict her and charge her for her abuser's damage. Again, Legal Aid Chicago intervened so that CH was able to move to a different unit with her subsidy, rather than being evicted from the unit that she was in. All right, moving on to sexual harassment. So the Fair Housing Act explicitly addresses harassment in housing, and it usually breaks it up into two categories. So generally, what is sexual harassment in housing? It's inappropriate touching, sexual comments, someone exposing their genitals, a housing provider requesting sexual acts in exchange for housing benefits. Who are generally the defendants or perpetrators in this situation? What we've seen is that the perpetrators of sexual harassment in housing are the people in a position of power. So that could be the landlord, it could be a building manager, a maintenance worker, a security guard. Those are typically the people we see engaging in this type of conduct. So what are the legal frameworks that we use? There's two legal frameworks that we typically use. So the first is quid pro quo. So what quid pro quo means is this for that. I mean, technically defined, but what quid pro quo really means is that a housing provider or an agent of the housing provider is threatening to take adverse action or withhold housing services in exchange for sexual conduct from the tenant. We're also able to use what's called a hostile environment type of harassment. So a hostile environment occurs when there is unwelcome conduct by a housing provider, or again, an agent of a housing provider, that is severe or pervasive and interferes with the tenant's use or enjoyment of their dwelling. So a single incident can create a hostile housing environment. So how do we do these cases? So we will file claims on our own. We file them in Chancery Court, we'll file them in federal court. Sometimes we'll file them as counterclaims to eviction actions. We also, of course, use the Commission for Human Relations. And then we also occasionally partner with the Department of Justice if there's a pattern and practice of this type of sexual harassment. So what does sexual harassment look like? So again, I've selected a couple cases that have come in during the COVID-19 crisis so you can see what these cases are looking in connection with the crisis we're experiencing. So the first tenant I'm going to speak about is DL. So DL also had a housing choice voucher. So what that means is that she can move with her subsidy rather than being forced to stay in her unit in order to retain her subsidy. So DL's landlord asked her out on several dates, and she declined to go on a date with him. After she declined to go on a date with him, he refused to accept her rent, and she tried to timely pay it. She was otherwise, a very good tenant. And what he did was he refused to take her rent, and then he filed a non-payment eviction case against her for failure to pay rent. And then once the eviction case was filed, he again offered to dismiss the eviction case if she had sex with him. So in this case, we agreed to represent her for the eviction case, and we intervened to make sure that the eviction case got dismissed based on his sexual harassment and the fact that it was baseless. Fortunately, DL and her minor daughter were also able to move with her subsidy while the eviction case has been pending. Moving on to AS, who's the second example I have here. So AS lives in just a regular apartment. She doesn't have any subsidy, and it's still covered by Fair Housing Act protections. So AS's landlord pressured her to engage in sexual activity with him. He sent her nude photos, and then he monitored her while she was home. So obviously this was a very scary situation for her. She also lived alone. And so we were able to safety plan with her, get her moved out of the unit, and then we filed a discrimination case based on the landlord's conduct. So looking forward, so now that you have kind of a basic understanding of the law and also some examples. So as financial instability continues in our communities, survivors of violence will continue to be more vulnerable to abuse. People in positions of power will attempt to leverage delayed rent payments or other tenant needs in exchange for sexual activity. At Legal Aid Chicago, we know that tenants deserve to feel safe in their homes, and we're committed to making sure that this happens.
And what else are we doing? Since COVID-19, the Housing Practice Group here at Legal Aid Chicago has endeavored to try to assist tenants in many different ways and avenues. The first is that we've been engaging in advocacy. We've been writing to and trying to work with the housing authorities so that they can adopt HUD waivers or otherwise a lessening of restrictions when it comes to recertifications and other requirements that you have to follow to live in subsidized housing. We've also asked for housing authorities to be lenient and work with tenants that cannot pay their rent due to COVID-19. We've also been sharing information. So if you look on our COVID, there are lots of infographics and flyers that let you know the current state of laws, what is happening, what your rights are, and also provides other information for tenants that need access to services. We've also increased our community engagement. So while lots of different organizations are moving to remote work, we have attempted to try to build connections and relationships with social service agencies to both support them and to also support residents that go to those social service agencies for help. We've created template banks so that we have sample letters so that housing advocates can use them throughout Cook County to try to assist tenants who are receiving notices that may be improper. And we've also started working on new projects, and those new projects are really trying to highlight and utilize the new COVID-19 Eviction Protection Act, where we can work with residents and landlords to not only try to work out an agreement, but to also get much needed rental assistance to the landlords to stave off evictions. And with that, I am going to pass it over to Melissa Pachola, our director of our volunteer service unit.
Great, thanks so much. And so I am not a betting woman by nature, but I'm going to go ahead and bet that there are about many of the 330 of you on the other side of my screen feeling overwhelmed by what you just heard. And as legal aid attorneys, when we discuss the challenges facing our clients and the people that we serve, we are often in the position of having to deliver grim realities. So as the director of volunteer services at Legal Aid Chicago, I am hoping to bring you an opportunity to take a deep breath, and while you absorb the information you just heard, start to focus on what you might be able to do to help. At Legal Aid Chicago, we have over 20 different pro bono opportunities. We simply could not meet the needs of our clients without the help of volunteers who work alongside us to serve our clients and help to bring about justice for all. You can see on this slide the high-level overview of our pro bono program and the impact that volunteers make. We have a variety of opportunities available, spanning all of the subject matters that we serve at Legal Aid Chicago and offering everything from a short-term commitment of a couple of hours to a longer-term engagement. We have also adapted many of our opportunities to allow for fully remote work during this pandemic. One opportunity that I want to highlight is the Eviction Mediation Project, which we have just launched in anticipation of the coming eviction crisis. Our goal in this project is to help tenants reach resolution with their landlord outside of court, which in most cases, and that's probably an understatement, the word most, is a win for both sides. We have a training available on demand to provide a background on the law and the mediation process. There is no obligation to represent tenants beyond the mediation in court or otherwise. And you can sign up to receive a case within a particular week, and we anticipate that most cases will resolve in less than a month. You can find more information about all of our volunteer opportunities on our website, and you are welcome to reach out to me with any questions that you may have about any of our opportunities and how you may be able to help. And now I'll turn it over back to John Gallo.
Thank you, Melissa, and thanks to Karen, Denerica, and Jackie for those fantastic presentations. I think that you can see that, especially by the response in terms of the participation for this event, that this has been a great start for our webinar series, and that we have an enormously talented team of lawyers and staff working to provide you with both information and further opportunities. So thanks to all of you for joining us today. That concludes the content portion of today's presentation. In a moment, we'll start the Q&A portion. Before we do that, a quick reminder, we'd appreciate it if you could fill out the survey about the presentation. And by the way, we've seen in the chat that some people are having difficulty getting through your company or your firm to the survey. So Contessa, who's monitoring the chat and the Q&A, will help you with that later. So we'd appreciate it if you'd fill the survey out. And if you'd like CLE credit, click on that link in the chat and fill out the form. So the panelists are going to stay here to answer questions and to respond to the Q&A at the bottom of your screen. And so with that, I'm going to turn it over to Denerica, who as our leader in this space is going to manage the Q&A. So Denerica, back to you.
Thank you. And I'm going to ask Melissa and Jackie both to come on and help me answer some of these questions.
Sure, Denerica, if I can just jump in right now. We've gotten several questions about whether the slides will be made available. And so the slides will be made available to all of the attendees after the presentation. So for all of these who are dying to get your hands on all those clever graphics, you will have them. So thanks.
I also tried to jump in and answer some of the Q&As that I could, that could be typed out pretty quickly. So I think we just have some left.
Okay, the first one, well, Jackie, since okay. If a tenant has been served notice, are they supposed to receive a new notice once the moratorium has expired, or can they begin arrangements before the moratorium? The landlord is not required to issue a new notice after the moratorium expires. With that being said, that doesn't mean that just because you've already received a notice that you cannot attempt to negotiate with your landlord or to otherwise work out an agreement. You can also attempt to try, if it's a non-payment of rent case, to access rental assistance. And finally, if you are taken to a court or eviction court, there are certain requirements that must be met before filing. And so you may still be able to avail yourself to a defense in the eviction case, just to make sure that procedural safeguards were met. What economic incentives do landlords have to evict in light of the likely difficulty finding other tenants able to pay? Are efforts underway to talk to major landlords and attempt to persuade them that it is in their interest to be reasonable and to facilitate tenant-landlord negotiation process? Well, you know, one of the things that I found in my experience is that sometimes evictions are not just about money, sometimes they're about principle. And sometimes money is not the issue when landlords file eviction, but I would hope that landlords would take advantage of rental assistance, both if they're in the county or in the city, and really try to avoid the eviction process. We are in the middle of a global pandemic, and at this time, it's really the time to rely on each other and to band together. And so hopefully landlords, whether they're large or small, will accept that challenge and work with their tenants to make sure that they can remain housed. Are there any new legal protections for small business tenants unable to pay rent due to revenue downturns occasioned by COVID-19? Does anyone else want to answer this one? To the best of my knowledge, I am not aware of legal protections for small business tenants. The only thing that I am aware of are those grants that were available for small businesses that were adversely impacted by COVID-19.
I think, Danica, also as a practical matter, when the courts were shut down, no one could file anything really or get anything heard. So there was some delay in enforcing evictions against small business tenants because commercial evictions were not being heard otherwise. But in terms of relief, I don't think that I'm aware of anything either.
Are the template banks you mentioned available outside of LAC for other legal aid advocates? Some of them are, and there are, I believe, some templates on Illinois Legal Aid online, and some of them you can also reach out or look at the National Housing Law Project. They may also have templates. We've been trying to work with them as well.
Danica, if you don't mind if I can jump in and ask this
Please
one that
do.
you sent through the chat. I think that Jackie, you can answer this. Does legal aid also provide assistance on the other legal issues that we are made aware of when addressing the tenancy issues, i.e. domestic violence?
Sorry. Yes, we do. One of the benefits of working at Legal Aid Chicago, and I've talked about this a lot because I feel very strongly about it, is that we're able to provide full service help to clients. So if I have a client with, I mean, any of the examples that I provided you today, which were my clients, I would probably have a partner in the children and family practice group if the client felt that they needed an order of protection. I think it's important to note that that's not always a safe option for people, but a lot of times it is. And if it is, then we're able to get that help. So it's really great.
And just to add on to that, that's just a reminder as well that we do have other practice groups at Legal Aid Chicago. We have children and family, we have public benefits, individual immigrant and individual workers' rights. So if there are other supports that you need, just reach out to us because we do other work outside of housing work and provide comprehensive legal services.
Yeah, and Danica, that's a great way for us to plug the rest of the webinar series. So this is the first of 8 webinars. And so if you're interested in learning more about the other work that we do, we encourage you to sign up for some of those other webinars so you can learn even more and connect with other experts.
The next question is it legal for a landlord to give a tenant a 30-day notice if non-payment is COVID related? That's actually required by the CARES Act. If it's a federally backed mortgage or a federal property, that the non-payment requires, after the CARES Act expires, landlords must give a 30-day notice after the expiration of the CARES Act. So it is legal, but this is where the city ordinance comes in, where you can try to negotiate with your landlord or work out an agreement and explain that the non-payment of rent was COVID related. And that gets you into the negotiation process of trying to work out an agreement. I heard that the moratorium applies to homeowners that have accepted Section 8 payments in the past. Is that true? Jackie, you want to answer this one?
Sure. So I feel like I'm reading all these questions and I think to myself, well, it depends sometimes. And I feel like that's how you know you're talking to a lawyer, right? So, I mean, you say moratorium, there's the governor's moratorium in Illinois, like Danica said, that runs through August 22nd. That applies to everyone. There was also the CARES moratorium, and that recently expired, and like Danica was talking about, requires a 30-day notice. For CARES, if the CARES covers federally backed mortgages and also federal subsidies that are covered by VAWA, included in that second group are housing choice voucher participants. So I think it depends a little bit on whether, it depends a little bit on the facts, but generally, yes, housing choice voucher subsidies were covered by CARES in the moratorium. Did I fully answer that?
I think so.
Okay.
What safeguards are there for a tenant who tries to work out something? Oh, I'm sorry, I skipped one. Is there any way that injunctive action would be taken against larger property management companies that have been engaging in predatory and discriminatory eviction actions? I think that's very case and fact specific. It depends. If a landlord, whether large or small, has engaged in discriminatory actions, then they could potentially be liable, and any injunction could also be filed, but again, that's very fact specific. What safeguards are there for a tenant who tries to work out something with your landlord and pays them some of the past due rent through a verbal agreement, and then the landlord takes their money and still proceeds to eviction? Melissa, you want to handle this one?
Oh, sure. So you're saying what safeguards are there for a tenant who tries? I think that, you know, there are the safeguards that we've sort of talked about are that you can try to dismiss that action as a result of the fact that, you know, if the landlord didn't engage in good faith. But the eviction protection, or the Eviction Act in Illinois, does not actually protect a tenant who partially pays rent if they made just a partial payment and the landlord demanded full rent. So I'm not sure if I'm answering the question exactly, but that's my understanding of the Eviction Act. And so the safeguards that exist are that, you know, you could try to go into court and defend yourself in another way. But in terms of partial payment, we actually need to be very careful with those situations because the Illinois Act is written such that a partial payment does not cure the non-payment.
And we strongly encourage you to get anything in writing. If you think that you have an agreement that you can stay through partial payment, get it in writing. Writing doesn't have to be a formal letter. It doesn't have to be notarized. It could be a text message that you have acknowledged by your landlord. But whatever you can do to get something in writing to say that you have this agreement, then get it. Because as Melissa said, partial payments after 5 days issued may not be enough. If you do receive a 5-day notice, you really should try to pay within the 5 days, or under the new COVID-19 Eviction Protection Act, try to work out an agreement in writing with your landlord and ask for that agreement.
Yeah, and it is, you can also ask for mediation, and you can also call Legal Aid Chicago to try to get into our mediation program if you feel like you had a verbal agreement that you'd like to reduce to writing to maybe renegotiate some of those terms.
What is the breakdown of ownership between corporate ownership of rental housing and private individual ownership of rental housing? I have no idea.
Yeah. I think that there's a lot of speculation. I'll just go ahead and say the politically dicey answer here, which is that there's a lot of speculation about mom and pop landlords that are being adversely affected by some of these tenant protections. You know, I think in our experience, it's less common than most people think, but I don't have the percentages either.
But what I would say is that one of the things is that for the small mom and pop owners of rental property, if the tenant isn't paying because of COVID related reasons, mortgage holders may request up to a year of forbearance on their mortgages, and that could afford a tenant time to catch up. That could afford a tenant a time to apply for rental assistance through the city or through IDA, because those applications just became live on Monday. And so there is rental assistance available. So I would encourage people to try to apply for some of those funds. Are there any restrictions on evictions where a tenant was served a 5-day notice and the eviction was filed pre-eviction moratorium?
Ooh.
Ooh. If the eviction was filed, well, those are the cases that are currently being continued in court right now. I wouldn't say that there are any restrictions, because if the case was filed prior to March 1st, then those cases, and prior to the moratorium, then those cases will proceed once the courts actually open up and that the cases actually, and that the courts actually proceed. But what I would say is that if a landlord does want to try to work it out with the tenant, there's nothing to say that you can't work out an agreement just because an eviction case has been filed. And can you provide the link or enrollment information for the legal aid mediation program, please? Melissa?
Sure. So you can go to our website at legalaidchicago.org and click on volunteer opportunities. Get involved in volunteer opportunities, and you'll see all of our programs, our volunteer opportunities listed, as well as the opportunity to sign up to be a volunteer.
And I think that's all for the questions.
I think we've got a couple more in chat, Denerica, sorry. Or Jackie, did you
may
take
have
those?
answered them. The two main questions, one was from Colson, who was asking about the changes about non-renewals.
Mm-hmm.
And so I answered that I believe essentially those amendments about notice times was effective July 22nd. And then I put the text to the change in the ordinance in the chat in case people wanted to see it firsthand. But the highlight of that change that Colson was asking about is that tenants are now entitled to notice of non-renewal or no cause termination based on how long they've lived at the property. So 30 days if they've been there less than 6 months, 60 days if they've been there between 6 months and 3 years, and 120 days if they've been there longer than 3 years. And of course, that applies to tenants in owner-occupied buildings of 6 units or less. And then someone also asked about criminal complaints, which I think is a great question. And I put in there that a lot of times the cases that I was talking about, especially sexual harassment, warrant a criminal complaint for what's been done to the tenant. And so I just said that we've spoken to ASAs about that issue very recently. Of course, legal aid would only do the civil part of it, but we do have a lot of partnerships to address this issue as broadly as we can.
Great. I think then we might have done it.
I think that we'll call it. All right, everybody. So thanks to everybody.
We did have one more question that came in.
Are there any remedies for a landlord when a tenant refuses to apply for rental assistance and accept payment plan offers?
These are good questions. This one makes me go, eviction court is your remedy, right?
I didn't want to say it. I didn't want to say it.
I'll say all the things you don't want to, Denerika. Okay.
Sounds like a law school exam.
Yeah. I think the remedy is that you can get an eviction order that'll be enforced by the sheriff and that tenant.
But that's it. That's it.
Yeah.
Okay, well, I think this is a good time, and Karen's popping back in reminds me that we should express a special gratitude to her and the Chicago Urban League, not just for partnering with us on this and in other things, but also for the work you do and for that fantastic 66-page report, Karen. I will tell you, I think you underestimate how interesting that is and how valuable it especially is. It's fortuitous that you were preparing that in the context, that you did.
Sure.
And it's really a fantastic tribute to the work that you do. We're so lucky to have had you participate with us in this, and we feel lucky to partner with you. So let us know when you want us to do a webinar, an Urban League webinar, and I'll send Melissa, Denerika, and Jackie to join in.
You know I will. You guys make a wonderful team, and you know I will, John, and you all make a wonderful team. And I really would be remiss if I did not give a shout out to the team who prepared that report under the leadership of Stephanie Schmidt-Beckler, because our research and policy team works really hard, and I'm happy to let them do all of the work and then to talk about it as if it is my own.
Well, it's not as heavy of a lift as you suggested, so I'd encourage all the participants. And thanks to the 189 of you gallant folks who hung with us all the way to the end. We'll give you back 19 more minutes of your life, and we'll see you next week. There's a question for you, Karen. Where can they get a copy of the report?
They can actually get it on our website at chiul.org, and you can get both the full report as well as the executive summary on our site under the research and policy section.
All right, for all of you guys who are still hanging in, we'll see you next Wednesday at 12 o'clock when we focus on domestic violence issues. It's a nice pivot from the presentation that Jackie gave today. Thanks to all of you for participating and for your support, and we're signing off. Thank you.